Honourable Leanne Dalzell.
Mr Speaker, I've read the regulatory impact statement for this bill, and I think that it is important to refer to it. It does traverse the history of the legislation. The legislation is doing something in this particular instance for which it was not originally intended. Originally, it was intended to ensure that private trusts would not fail through the lack of a replacement trustee. And I guess as we've moved into a modern environment with securities now having trustee appointments, the potential for what has actually occurred in this one instance has in fact arisen. And I think it is appropriate for the government to act to cut it off at that point. So we are in agreement on this side of the House with respect to the intent of the legislation and the fact that it would apply from today's date. There are two different ways that you can make legislation apply from today's date. One is to do what the government's doing, and that is to pass it under urgency through all of its stages without the benefit of a select committee hearing and without advice from the Law Society and without advice from any trustee company, because in fact the trustee companies couldn't be consulted in this bill being developed because, of course, of the conflict of interest and the fact that it would alert those companies to the fact that the government was going to do precisely this. So I actually think that the second option would have been the preferred way to go given those limitations, and that was to announce that today would be the operative date for the legislation, that it would come into effect from today, even though it would be passed in a fortnight's time. Because I, like everyone else, would rather see the certainty of having the timescale truncated, but I, for one, would always prefer to hear what the Law Society has to say in a considered submission to a select committee, and then to have the officials respond to that and to provide the committee with advice. And maybe it would have been more than a couple of weeks, but with the date in concrete, that would have prevented any other application being filed, because at the point, a simple transition point, and I can see Kate Wilkinson shaking her head, but the transition clause could simply say that any case filed after today's date would not have the benefit of the application of that particular provision. So there is, with a good deal of sort of working through these issues, I honestly think that we could have come to the best of all worlds. And the only thing that just concerns me is that we are now going to substitute that select committee process with a committee stage where we will ask questions about the wording of Section 46. I guess that one of the questions that I'll be wanting to know is whether this in any way, is this the same provision that is due to come into effect with the provisions of the Financial Markets Conduct Bill, which I understand the government hopes to have passed by June and in effect later on. If that's the case, that would be incredibly useful information, but on the face of it, it doesn't seem to me to explain whether this is in fact the wording that's been taken out of there. I don't know. So there's detailed stuff that I'd like to know, because the last thing that we want to do is, when we're addressing the unintended consequence of perfectly good legislation that has just become outdated because of the circumstances that we now find ourselves in, that we create the potential for another unintended consequence down the track if we haven't got the wording quite right. And it is very difficult to amend these things. Obviously, it's much easier to amend these things with a select committee process. So I agree with my colleague Andrew Little that this is very much a case where we're on all fours with the government in terms of process, but in terms of content policy, the outcome that we want to achieve, we're not entirely happy with this process because it just brings such risks with it. The last thing that I just wanted to comment on was the finance company failures, which actually lead us to this position today. And I just want to make this point, and I've given the odd speech in the past because I was the Minister of Commerce at the time that the original finance companies started their cascading effect into failure. And the point was often made that the finance companies weren't regulated. That actually isn't correct. The finance companies were under-regulated. The supervisory role of the trustee was what was supposed to protect the investors from what actually happened. And I want to remind this House that when Neville Harris reported to the select committee that I chaired after the fact, he said at the time that at least 25 of the failed companies at that point had used just 2 trustee companies, Perpetual Trust and Covenant Trustee. And I think that we actually have to think long and hard about how we let that area of what was supposed to exist as a regulatory protection for investors, how that was so utterly failed in this particular instance. And I do, want to place on record again my absolute, concern for those that lost a substantial amount of money in all of those company failures, and that there were people out there who had roles that were supposed to act towards protecting their interests, and they simply failed to do so.
Dr. Jackie Blue.
Thank you, Mr. Speaker. I'm very pleased to speak to the